Welcome to the latest housing law update. I want to tell you about the case of Southern Housing Group versus Stephen Berry. This was a decision of Deputy District Judge Martinsky, and it's an important case about disclosure in injunction applications. The case concerned a dispute between Mr. Berry and two of his neighbours. Complaints had been made to Southern Housing Group about the incidents and also to the police. The police were investigating both Mr. Berry and his neighbours in relation to threatening behaviour, and there was evidence that both Mr. Berry and his neighbour had mental health difficulties, which were being seriously exacerbated by the ongoing dispute. The Housing Association and Southern Housing Group decided that Mr. Berry was the problem. They applied for an injunction on a without notice basis. The application was supported by a witness statement of a housing officer. The injunction was granted in Mr. Berry's absence, and a power of arrest was attached, so a very draconian remedy. At the return date for the injunction, the issue of whether the Housing Association had failed to make full and frank disclosure at the without notice hearing was raised. The matters that the Housing Association were aware of at the without notice hearing but did not disclose to the judge were firstly the fact that Mr. Berry had a long history of mental health illness, and secondly, that he'd made counter-allegations against his neighbours. Neither matters were disclosed, and as a result of that, Deputy District Judge Martinsky discharged the injunction because there had been material non-disclosure. He was also critical of the Housing Association witness evidence, which he said was highly partisan. This is a timely reminder for landlords that they have to give full and frank disclosure in these sorts of injunctions. Otherwise, they're going to find themselves with an interim injunction that's been discharged. Thank you.